Hi there. Welcome to another episode of Bringing the Law to Your Doorstep series. Today we'll be discussing a very interesting subject matter, the subject of the Adult Dependent Relative Visa. However, before I proceed to talk about it, I'd like to mention that immigration law is such a fluid area. Immigration law is always oscillating, changing from one point to the other. It's not static at all. So I can make a statement on a position of law today, and in the next second, the laws will be changed. Hence, the position of law will be radically different from what I initially mentioned or what I originally spoke about. So I always advise clients and people who come across various information, especially on legal matters online, to make sure that ultimately, before they make a decision on taking any line of action, it's very important to consult experts in that particular area of law. It's very important to seek professional legal advice before embarking on any legal journey. So what is the Adult Dependent Relative Visa? The Adult Dependent Relative Visa, which I personally call the ADR visa, in my own words, is a special type of visa which is intentionally designed to afford adult relatives outside the United Kingdom the opportunity to join their families in the United Kingdom, in the UK, and to have access to essential care and support. Now, unlike many other family visas, there are very stringent eligibility requirements for this type of visa. In fact, some immigration lawyers will tell you that it's notoriously difficult to be able to secure the Adult Dependent Relative Visa or the ADR visa, because when you go through the various laws surrounding this type of visa, when you read the Appendix ADR and the policies, basically the law surrounding this type of visa, there are a lot of requirements on the part of both the sponsor, that is the individual in the United Kingdom, as well as the applicant, the individual outside the United Kingdom who wants to be sponsored to enter the UK. Yes, there are validity requirements, suitability requirements, financial requirements, relationship requirements. There are a whole lot of requirements that you would need to satisfy under the law to be able to have access to this type of visa. Now, obviously, I won't be able to cover everything in this particular video, but it's my goal to be able to hammer on the very salient aspects of this particular visa and to help you navigate your way around it, ensuring that at the end of the day, your chances of securing it become very high. So this visa is specially designed for people who need long-term personal care. So assuming you've been a victim of an accident, assuming you've been suffering from a deteriorating mental or physical condition, which has basically worsened over the years or over a period of time. If you are looking at having access to that kind of care and assistance from a family member in the United Kingdom, then this visa is tailor-made for you. Now, in this video, I'm going to be using certain words consistently in my presentation, and these words are sponsor and applicant. Now, who is the sponsor? The sponsor is that individual or family member in the United Kingdom looking to have another family member outside the UK join him or her here in the United Kingdom. The applicant, on the other hand, is that individual or family member outside the United Kingdom in need of long-term personal care and looking to join his family member here in the UK. Now, it's important to know that once the ADR visa is granted, it could lead to indefinite leave to remain, or if you like, permanent residency, provided that the sponsor is a British citizen or has indefinite leave to remain in the United Kingdom. However, if the sponsor has temporary permission, then the applicant would only be entitled to live in the United Kingdom for the duration that the sponsor is entitled to remain or to stay in the United Kingdom. So let me make it more practical. And this is a hypothetical situation. Let's assume that as a sponsor, I'm looking at having my ailing mother join me from outside the United Kingdom here in the UK so that I can provide her with the needed assistance and support in her day-to-day activities. Now, if I have limited leave to remain in the United Kingdom, if I have about 2 years to stay in the United Kingdom and that my leave to remain expires at the end of the 2-year period, it means that my mother can only be entitled to live in the United Kingdom for a period of 2 years. However, if I'm a British citizen or I have settled status in the United Kingdom, my mother automatically gains permanent residence, if you like, or indefinite leave to remain in the United Kingdom once her application for the ADR visa becomes successful. So yes, the period of time to which an applicant will be entitled to remain in the United Kingdom is strictly dependent on the immigration status of their sponsor. So what are the eligibility requirements under the ADR visa? Number one, the sponsor has to be a British or an Irish citizen or needs to have settled status in the UK. Number two, the sponsor has to be protected. That is, he or she has to be a refugee or needs to have humanitarian protection. Number three, the sponsor has to be an EEA national with limited leave to remain or enter the United Kingdom, granted under Appendix EU. Now, I know that sounds quite technical, but in the forthcoming videos on this particular platform, I look forward to discussing very relevant subject matters relating to Appendix EU. So what are the eligibility requirements to be satisfied on the part of the applicant who is outside the United Kingdom? Yeah, so like the sponsor, the applicant must be 18 years or above and must be the grandparent, the parent, the son or daughter, or the brother or sister of the sponsor. So establishing strong familial ties to be able to support your application is extremely important in ensuring that your visa application is successful. Now, you'll need empirical evidence to be able to substantiate some of these familial relations. So what are some of the documents that you need? You can use birth or adoption certificates and other forms of evidence, documentation to be able to prove the kind of relationship that you have with your sponsor. So yes, there are relationship requirements that have to be satisfied when you're applying for this particular type of visa. Number two, you must require long-term personal care due to illness, age, or disability. Now, it's important to note that if you require long-term personal care, but the reason or the motivation behind that requirement is not grounded on these three factors, then you are not eligible to apply for the ADR visa. The factors are your age, illness, or a situation of disability. And we do always advise clients that anytime you want to tender in an application for this particular type of visa, on the subject of providing empirical evidence, to be able to support the fact that you require that long-term personal care based on any of the aforementioned factors, that is illness, age, or disability. We always advise clients that seeking generic medical reports about a particular mental or physical situation or condition is not enough. We would need expert reports on your condition, on your mental or your physical condition. So if you have a specialist, a medical practitioner, or a health professional who has dealt with you over a period of time and can write a report evidencing the fact that you require long-term personal care, or that the care is not available in your home country, or that the logistics or the facilities in your home country are not enough to be able to provide adequate care for you, then yes, that will suffice as perfect evidence to be able to support your application. So yes, you can't just go out there and gather evidence and generic medical reports or articles that medical practitioners or medical professionals have written on your condition, for example, to just support your application. We would need specific medical evidence coming from someone who has probably catered for you over the years. Number three, the onus will now lie on the applicant to be able to prove empirically that care is no longer available in their home country or in their country of residence, or that the care they need is not affordable. They just don't have the financial means to be able to afford that care in their home country. Now, in providing this evidence, a substantial portion of this evidence or this documentation won't have to come from the applicant. We always advise our clients that it's important to get this evidence from local authorities or local health organizations within your home country or your country of residence, establishing the fact that, yes, like I initially mentioned, the facilities are not available. They haven't gotten to that level in medical expertise where they have the technical ability or capacity to be able to handle your health situation. Now, on the issue of affordability, on the applicants providing evidence to support the fact that they cannot afford the care they need in their home countries or in the country of residence. Now, if previous payments were being made by your UK sponsor or any other family member or anyone at all to be able to provide the needed medical care and attention for you, the entry clearance officer or the caseworker dealing with your matter might probably request for these payments and would also request for a very detailed explanation on why these payments cannot continue. Yeah. So it's important to know that it's not enough to assert that you can't afford the medical care within your home country. You need to provide a detailed explanation as to the reason why you don't have the financial means to be able to seek the needed medical attention in your home country. All these factors are taken into consideration when assessing an application under the ADR visa. It's also incumbent on the applicant to be able to prove empirically that their sponsor has the financial means to be able to cater for them during the entirety of their stay in the United Kingdom. So if your sponsor has limited leave to remain, let's say for a period of 2 years, they should be able to prove empirically that for that period of 2 years, they have the financial means to be able to cater for you. In fact, it's a draconian process. Okay, I'm not trying to exaggerate, but at times bank statements for about 6 months preceding the date of your application will need to be submitted. And all these documentation will have to be gone through exhaustively before granting you this particular type of visa. At times, the abode or the residence of your sponsor within the United Kingdom would have to be inspected to ensure that once you join them in the United Kingdom, it is not going to contravene regulations on public health and on overcrowding. All these factors are taken into consideration. That is why I initially mentioned in the video that it's notoriously difficult in the view of many immigration lawyers to be able to successfully apply for the Adult Dependent Relative Visa. So you need to make sure that your documentation is on point, both on the part of the applicant and the sponsor, before this visa is granted to you. If your sponsor living in the UK is a British or Irish citizen or has settled status in the UK, they will need to be able to prove financially that they can support you for a period of 5 years. Now, for how long can an applicant remain in the United Kingdom once his application for ADR visa is granted? Now, on this particular subject, I like to say that the applicant is like a marionette dancing to the tune of a sponsor. So how long you can stay basically depends on how long your sponsor is entitled to stay in the United Kingdom. So if your sponsor is a British citizen or has settled status, then you have indefinite leave to remain. You can permanently stay or live in the United Kingdom. Now, if your sponsor is a refugee or has humanitarian protection, you can stay in the United Kingdom for as long as they are also entitled to stay here in the United Kingdom. Now, you can only apply for an extension of your stay, or you can apply for settlement once they also do same. So yes, your entitlement to stay in the UK is totally dependent on the immigration status of your sponsor. And one thing that the applicant also has to prove is that no person should be able to reasonably provide the care that you need in your home country or in your country of residence. So yes, in the eyes of the UK Home Office, questions that can be asked would be, do you have other family members in your home country or in your country of residence who can provide the care that you need? Okay. If you don't have close family members, do you have friends? Do you have relatives? Do you have a housekeeper, a home carer who would be able to provide the needed care to augment your situation? The UK Home Office takes a critical look at all these things. Now, even if someone was taking care of you at a certain moment, do we have evidence to be able to prove that that kind of care cannot be continued for a certain period of time? Has there been a change of circumstances surrounding the care situation that you need? All these factors are critically assessed by the UK Home Office when deciding whether or not to grant the application for the ADR visa. So what are some of the things you can do and cannot do under the ADR visa? Number one, you can generally work and study in the United Kingdom. So yes, you can be self-employed, or you can work in another capacity as an employee of another organization under the ADR visa. And for the studies, there are a few qualifications in there that I might talk about in one of my forthcoming videos. I hope to do that very soon. Two, you can live with your sponsor. Yeah, so this is like gives you the opportunity to join and live together with family in the United Kingdom. Number three, you have access to medical care, access to health services in the UK. So what are some of the things you cannot do under the ADR visa? Number one, you don't have recourse to public funds. Number two, you cannot extend your stay independently of your sponsor. So if your sponsor doesn't have indefinite leave to remain in the United Kingdom and their visa expires or they leave the United Kingdom, then your status as an ADR visa holder may be affected. So thank you so much for joining me on this episode of Bringing the Law to Your Doorstep series. Don't forget to subscribe for more detailed expositions on immigration related matters. And like I always say, at King's Court Law, your success is our motivation.